You should be focused on getting better and recovering from your injuries. By contacting a lawyer quickly, they're able to do that for you.
If you're injured in a car crash, do you know what to do? Well, that's what we're going to ask the lawyer today. Hi, I'm Rob Rosenthal with AskTheLawyers.com, and this is Ask the Lawyer. My guest is attorney Tyler Bailey with the Bailey Law Firm in Columbia, South Carolina. Tyler, thank you for making some time for us today. Answer our questions.
Anytime.
I appreciate
Thanks
it.
for having me.
So let's start off. You've told us before, when you're in an accident, one of the first things you do, obviously, you get help if you're injured, but contact an attorney. Why is it important we contact an attorney, and why is it important we do it sooner rather than later?
Well, addressing your immediate problem of being injured in a car wreck as soon as possible is the most important thing that you can do.
Right.
And the first thing you need to do, other than treating your injuries, is contacting a lawyer. They're going to be able to address issues that you're not going to be able to address. They'll be able to make sure that liability is established on part of the at-fault driver. They can assist you getting your rental car. All you need to do is focus on recovering for your injuries, and your lawyer, if contacted quickly, will be able to jump on things real early rather than there being a lot of stress and delay if you try and figure it out on your own.
What about gathering any evidence or anything like that for your case? That's something an attorney can help with too?
Oh, yeah. So the lawyer will also gather evidence, of course. They may have a private investigator go to the scene, take photographs of the vehicles, of any skid marks. Stuff like that will disappear if you delay. They will also contact witnesses, get their statements, get those statements notarized. Witnesses sometimes move to different states. If you wait and try to handle these things on your own, you're more than likely not going to have the tools, resources, time, or energy to get all that done. But your lawyer will be able to get it done for you.
Sounds like it can really take a big burden off of the person who was injured too.
Yeah, that's the most important thing is after being injured in a wreck, the last thing you want to be worried about is trying to track down witnesses or establish liability. You should be focused on getting better and recovering from your injuries. By contacting a lawyer quickly, they're able to do that for you.
If someone's injured in an accident, Tyler, and I'm assuming that means they can't work, they can't earn an income, is there a way something can be done to help with medical bills?
Oh, there is something that can be done with medical bills, and that's another reason why you should contact a lawyer quickly. Medical providers, most things that they're concerned about is getting paid. If you're trying to handle it on your own, they're going to be sending you letters. They're going to be calling you to collect on your bills. If you contact a lawyer, your lawyer can let them know that you were injured in a wreck and that they will be reimbursed for their services at the conclusion of the case when there's a settlement or verdict. They can send a letter of protection to the medical provider, which pretty much notifies them that as your attorney, they will make sure that they're paid those medical bills. So you shouldn't be worrying about trying to pay those medical bills, especially after you've been injured and you're trying to recover. Your lawyer can send them a letter of protection, which will probably, in most circumstances, stop all collection efforts on part of the medical providers.
Well, so once again, that's another burden lifted off of you. What if the other driver doesn't have very much insurance or has no insurance at all? What are my choices there? What can I do?
Yeah, so you have two options. If the driver does not have any insurance at all in South Carolina, all vehicles are required to have uninsured motorist coverage. That means if you have insurance and you're injured by a driver who does not have insurance, your insurance company will cover you for the at-fault party's damages. Now, if the at-fault party does not have enough insurance, if you contract with your insurance carrier for underinsured motorist coverage, then your insurance will cover the difference. So if the at-fault driver only had $25,000 in coverage, and you have $100,000 in damages, the at-fault driver's insurance company, or what I would do is make them pay the entire policy limit of $25,000. And then if you had underinsured motorist coverage, we could present a claim to your own insurance on part of the damages that are uncovered by the at-fault drivers and recovering the difference.
So in your opinion and your experience, is underinsured motorist coverage something you recommend people get, and as much as they can afford?
Yeah, I recommend people get as much underinsured motorist coverage that they can afford. The bare minimum is $25,000. I usually recommend at least $100,000 or more in underinsured motorist coverage benefits.
Are there different levels of uninsured motorist coverage, or is it just one level?
Well, so that's a good question. Your uninsured motorist coverage is going to be the limits of your own liability coverage. So if you have $50,000 in liability insurance coverage for your vehicle, then your uninsured motorist coverage will match that. And that's mandated by South Carolina law.
should I expect in these kind of situations that I might hear from the at-fault drivers, the other driver's insurance company, and do I need to be careful? Do I need to talk to them at all, or do I need to be careful about what I say to them?
You need to be extremely careful about what you say to them. And I only recommending speaking with them just to get their contact information. If you already have a lawyer and the insurance company contacts you, pick up the phone, tell them that you have a lawyer, give them your lawyer's contact information, and they will contact your lawyer. If you do not have a lawyer at the time the insurance company is contacting you, you can pick up the call just to get their name, which company they're with, what the claim number is, their phone number, mailing address, fax number, and email address. Once you get all that information, you'll tell them that you're going to contact a lawyer. You will give your lawyer their contact information, and then your lawyer will contact them. You need to be careful what you say to the insurance company. Anything you do say to them will likely be used against you in your case. And more than likely, unless you are a lawyer who practices in this area representing themselves, you do not know what to say to the insurance company. So you need to allow a lawyer to speak to insurance company in any event. If you don't, just get their contact information and give that to a lawyer when you do retain one.
How does it work in South Carolina? What if I think I may be partially at fault in the accident? How does that work in South Carolina? Could I still have a case?
Yeah, so in South Carolina, you still have a case as long as you're not more at fault than the other party. So as long as you're under 50% at fault, you still do have a case. Things like thinking you're at fault are things you need to tell your lawyer, and you definitely don't need to tell the insurance company that, although you may think you're partially at fault. The fact of the case may actually show that you're not at fault, or in any event, you're barely at fault compared to the negligence of the at-fault driver. The good thing about South Carolina is even if you are partially at fault, you're still able to recover for your damages.
And who decides how at fault I am? Is that, I guess if it ultimately goes to a jury, that would be up to the jury to decide the level of fault?
That's right. So if it goes to a jury will determine between the parties what percentage they're at fault. A lot of times insurance companies, if they believe you're partially at fault, they may pull an arbitrary number out of their pocket and they say you're 30% at fault or 20% at fault. A lot of times I give no weight to what the insurance companies believe my clients are at fault, because more than likely a jury of your peers may see the case differently, and they may, even if you are at fault, they may apply a lower percentage to your liability than the insurance company believe you are early on.
Tyler, once again, lots of great information. I appreciate your time. Thanks for answering our questions again.
Thank you. My pleasure.
That's going to do it for this episode of Ask the Lawyer. My guest has been attorney Tyler Bailey of South Carolina. If you want the best information or you're ready to choose a lawyer that lawyers choose, make sure to visit askthelawyer.com first. Also, please take a sec to like, share, and subscribe by clicking below. Thanks for watching. I'm Rob Rosenthal with askthelawyer.com.